Good evening, everybody. Today in the demo class, I am going to discuss regarding recording of evidence of vulnerable witnesses, as well as protection of witnesses in criminal matters. So this is a very important aspect of criminal law also, especially when you recollect that amendment was done way back in 1983, where Section 375, Section 376, and of Indian Penal Code and Section 114A of Indian Evidence Act were added along with subsections 2 and subsections 3 of Section 327 CRPC, where it was mandatory that the trial has to be conducted in camera and the proceedings of the said trial have been forbidden to be printed or published except with the previous permission of the court. That is in the rape matters. So keeping in view the amendments in Section 375 and Section 376 Indian Penal Code, along with Section 114 of Evidence Act, as well as the new sections which were inserted at a subsection 2 and 3 of 327 CRPC, it was held that the courts are obliged to act in furtherance of the intention expressed by the legislature and not to ignore its mandate, and must take recourse to the provisions of Section 327, subsection 2 and subsection 3 of Criminal Procedure Code, and hold the trial of rape cases in camera. So when I talk about the history, as I've just told you all, that the amended acts of CRPC and Indian Evidence Act, along with Indian Penal Code, the code through various judicial precedents were adding the new conditions, and those will be discussed with you with plethora of judgments of Honorable Supreme Court. The first judgment which comes to my mind is State of Punjab versus Gurmeet Singh. Now this judgment is of 1996. So here in the Apex Code, held in para 34, that the provisions of subsection 2 of Section 327 CRPC shall, in addition to the offences mentioned in the subsection, also apply to inquiry or trial of offences under Section 354 and 377 Indian. Further, it held that in holding trial of child sex abuse or rape, a screen or some arrangements may be made where the victim or witnesses does not see the body or face of the accused. Further, it held that the questions put in cross-examination on behalf of the accused, insofar as they relate to directly to the incident, should be given in writing. I again repeat, the questions which have been put by way of cross-examination should be given in writing to the presiding officer. Presiding officer means judicial officer, magistrate of the court, who may put them to the victim or witnesses in a language which is clear and not embarrassing. See, here I will try to elaborate that these trials are very, very sensitive trials. You cannot use a foul language. You have to be very, very sensitive. Seeing the sensitivity of the victims involved, especially in these sections, the courts have to be extra cautious. Further, it held that the victim of child abuse or rape will give testimony in court. While giving testimony in court, should be allowed sufficient breaks as and when. Further, Delhi High Court. So this apex court judgment, which I just told you, was of Sakshi versus Union of India. Now this is a case of 2004, volume 5, Supreme Court cases, page 518. Moving further, there was a further guidelines by the Delhi High Court. So here the guidelines of the recording of deposition of vulnerable witnesses were framed by Honorable Delhi High Court. So you can write the name of the judgment. It is Varinder versus State of NCT of Delhi. Moving further, the apex court in 2018, recently, in state of Maharashtra versus Bandhu. Now this is judgment of 2018, volume 11, Supreme Court cases, page 163. Here the apex court adopted witness protection scheme, 2018 in its entire. So there the directions which were laid down in the case of state of Maharashtra versus Bandhu. So which is this case? The case which I just discussed with you earlier was retreated by the Honorable Supreme Court. Moving further, here there was a landmark case where the Honorable Supreme Court gave the guidelines as well as defined the definitions, which are very, very important for all of us to understand. So let us talk about the landmark case of Supreme Court, which was held in 2019. It is Samruti versus State of Maharashtra. This is a 2019 case. So here it has been clarified the definition of vulnerable witness contained in clause 3 of Vulnerable Witness Deposition Center scheme formulated by Delhi shall not be limited only to child witnesses who have not attained the age of 18 years, but would be expanded and include the following categories. So it has roughly given around 7 categories. So A, it includes age-neutral victims of sexual assault, which is read with section 273 and 327 of CRPC, along with section 354 of IPC. B, gender-neutral victims of sexual assault, read with section 2, clause D of POSCO Act. Third, age and gender-neutral victims of sexual assault under section 377 IPC, read with para 34 clause 1 of the decision in Sakshi versus Union of India. So this is very important judgment, Sakshi versus Union of India, particularly para 34 clause 1. I expect all of you to read it and further add to the guidelines which I am just dictating you. Let's go to the fourth guideline. Fourth guideline was witnesses suffering from mental illness, as defined under section 2S of Mental Health Care Act 2017, read with section 118 of Indian Evidence. Further, any witness deemed to have threat perception under the witness protection scheme of the Union of India, as approved by Supreme Court in Mehen. Now, this is a very important case. Supreme Court in Mahindra Chawla versus Union of India. Now, this is again 2019 Supreme Court case. Second last guideline was any speech or hearing impaired individual or person suffering from any other disability who is considered to be a vulnerable witness by the competent. So who will decide here? The competent court. Which category of people? Where any speech or hearing is impaired and this person is suffering from any other disability. Last but not the least, any other witness deemed to be vulnerable by the court concerned. So it is you, the magistrate court, which will finally take a call whether this category of persons come under the definition of vulnerable witnesses. So further moving, now I'm talking about vulnerable witnesses. So what is the definition of vulnerable witness? Basically, vulnerable witness is a child who has not completed the age of 18 years. But here, the Supreme Court, through landmark judgment of Samriti's case, which I just dictated before giving you this further elaboration, where I have given you the conditions, it has basically widened the scope of vulnerable witnesses. The general definition is any child who has not completed age of 18 years. Now here you should also remember Juvenile Act, because Juvenile Act has to be read along with whenever you talk about vulnerable witnesses. So Juvenile Act, Indian Penal Code, CRPC, as well as the Indian Evidence Act. All these provisos have to be read together to get the clarification and get to the gist of the fundamentals of these principles. Moving further, there are a few more definitions which I will like to elaborate. For example, support person. Who is a support person? It means and includes guardian, legal aid, lawyer. You can also call facilitators, interpreters, translators, and any other person appointed by court or any other person appointed by the court to provide support, accompany, and assist the vulnerable witnesses to testify and to attend judicial proceedings. Further, I'll elaborate on concealment of identity of witnesses. So, what do you mean by concealment of and identity of witnesses? It means and includes that any condition prohibiting publication of the name, address, and other particulars which may lead to identification of the witness. Moving further, duties of guardian. So it shall be the duty of the guardian. In Latin word, we say guardian ad litem, ADLITEM. So what will be the duties? First, attend all depositions, hearings, trial proceedings, make recommendations to the court concerning the welfare of the vulnerable witness, keeping in view the needs of the child, and observing the impact of the proceedings of the child. Next, explaining the language understandable to the vulnerable witness, which includes the legal proceedings, police investigations in which the child is involved. Last, assist vulnerable witnesses' family in coping with the emotional effects of crime, as well as remain with the vulnerable witness while the vulnerable witness waits to testify. So all these parameters are very important, and I think all of us are learners till the end of the day. I always believe knowledge is the biggest investment. So these trials are very, very crucial, very, very important trial, and a lot of precaution, sensitivity to the vulnerable witnesses, protection to the vulnerable witnesses is always taken as a paramount duty of them. So you should also know what are the rights of the vulnerable witnesses. For example, it is a right of the vulnerable witness or his or her parents to be promptly informed by the court about the stage of the process to the extent feasible and appropriate about the following. What? Proceedings in criminal justice include the role of vulnerable witness, importance, timing, manner of testimony, existing support mechanisms for vulnerable witnesses, specific times and place of hearing, available of protective measures, relevant rights of child victims and witnesses pursuant to application of laws, progress and disposition of specific case. So these are the important rights to be informed to the vulnerable witnesses. So there has to be comfortable environment, I've told you. So competency of vulnerable witnesses. Every vulnerable witnesses shall be presumed to be qualified as a witness unless prevented by the following. First, age. B, physical or mental disability, leading to recording a finding of doubt regarding the ability of such witness to perceive, remember, communicate, distinguish truth from falsehood, or appreciate the duty to tell the truth or to express the same. So persons allowed to add competence assistants, who are them? Obviously the judges, counsel for the parties, guardian ad litem, one or more support persons of the child. So all these parameters are very, very important when we consider the protection, the recording of evidence of vulnerable witnesses. So this is a very, very important topic for all of us to remember. And further, if I move to the next topic, that is protection of privacy and well-being of child victims and witnesses. So to conceal the description of the child witness, to examine what parameters are there behind the screen, obviously, use image or voice altering devices, through examination in another place, transmitted simultaneously to the courtroom by means of video link, through a qualified and sustainable intermediary, holding closed sessions, temporary removal of the accused from the court room to an adjacent room with a video link, or a one-way mirror visibility into the courtroom, but allowing the defense counsel to be present in the court. Taking any other measure which the court deems necessary. High priority be to be given to vulnerable witnesses, and there should not be unnecessary delay or latches in these matters. So, a direction for judges holding criminal court. What are these directions? At any stage of the proceedings where the safety of child victim or witness is deemed to be at risk, the court shall arrange to have protective measures of the child, which may include, first, avoid direct or indirect contact between a child victim or witness and the accused at any point in justice process. B, restraint orders. C, a pre-trial detention for the accused or with restraint or no contact bail conditions which may be continued during trial. Protection of child victim or witness by the police or other relevant agencies, and safeguarding the child from disclosure. And the last is any protective measures that may be deemed appropriate. Then I come to witness, very important topic, that is witness protection scheme. Now this protection scheme was laid down in 2018, and I'm sure none of you must be aware of all these things. See, when I talk about law, you should be aware of what is happening around. What are the latest schemes, the orders, the enactments, because these guidelines are very important. Unless or until you are not aware of these things, you will never ever in life understand how to record evidence of a vulnerable witness. Because you see, in practical life, how this happens. There is a case, and this is a real case. A mother was killed in front of a child, in front of the only child. So that child is the witness who has seen that heinous crime committed against his pious. So here the trial will begin. Here the experience will count. Here these guidelines will come into picture. That is why I say law is not just reading from the Bare Act and reading from the Punji's. Law is what you practically practice in the courts. You should have wider understanding of it, and you should try to read in the lines. Unfortunately, none of us go through the detailed aspects of any stream unless or until you have experience. So I am here to assist you in your vision of understanding the principles of law. So Witness Protection Scheme 2018 is very, very important. So that's you will all go through it, what it is, and then we'll conclude at the end that today's topic was regarding the examination of vulnerable witnesses and protection of these witnesses vis-a-vis the protection scheme of 2019. So your homework will be to read about this scheme of 2019 and 2018 and share your inputs on the next session. Thanks everybody. God bless you all.